Good morning. A warm welcome and many thanks for this kind introduction, and also to the Vienna University for inviting me and basically being interested in this perspective of national jurisdictions as well. So what I decided for a title was actually to explain why basically national jurisdictions are in the front line of fighting impunity for core international crimes. We heard yesterday from the keynote speaker, Professor Zerbes, and his thoughts about the duty of states. And I will actually see a bit more about how these duties are implemented by national authorities, by states. I need to be honest that, of course, whenever we speak about the front line of fighting impunity, we predominantly look into the prosecution or investigations based on the principle of universal or extraterritorial jurisdiction. And we need to be quite frank that this is not the ideal situation. Of course, the ideal situation is to investigate and prosecute these crimes in a country where they have been committed, because that's where you have victims, witnesses, the affected community, and all the other evidentiary material. So, of course, the countries where the crimes have been committed are the best placed for these proceedings. However, often these countries deny justice to victims. They don't have access to justice in those countries. And then the second best option is, of course, to use the extraterritorial jurisdiction and basically the principle of universal jurisdiction and the principle of duties of states to prosecute these crimes. So that's something that we need to be always have in perspective, that this is always the second best, but it's very important because otherwise there would be no justice. That's what we also need to keep in mind. Brilliant. So when we try to understand how European jurisdiction work in this field, of course, we need to understand that they basically also, whenever we try to understand the position of each country, we need to have in mind that basically countries need to cooperate, because you always have the evidence, the victims, the witnesses, they disperse. So whenever we look into the conflict, of course, victims, witnesses, and also perpetrators, they flee, if there's a, depending on the warlock. And in that way, you need cooperation. Now, the Genocide Network was set up for this purpose back in 2002. So we need to go a bit back in time, what happened in 2002. At that point, we had the setting up of International Criminal Court with the principle of complementarity as in its essence. And Netherlands and Denmark at that point initiated to set up a network of practitioners who would assist each other in basically sharing information, but also in sharing best practice, knowledge, and so on, to be able to actually implement the principle of complementarity. Let's not forget the Rome Statute defines relationship between a state and the court, but not between the states. And that's in a way where the founders, the idea behind the Genocide Network is to enable states, EU states, to cooperate and to basically assist each other as well. So that was the decision of the Council of the European Union back in 2002. And then later on, the Secretariat was set up at Eurojust. That's a European Union Agency for Judicial Cooperation. We're based in The Hague. And again, this is network of contact points. So it's basically practitioners, investigators, prosecutors, MLA legal officers that are part of this network. And the main idea, of course, the objective, the mandate of the network is to prevent EU becoming a safe haven. So to cooperate between jurisdictions to prevent perpetrators walking around freely, to put it that way. Our membership is very unique as such. Thinking about globally, I think we can position ourselves as a front runner. We have on one side, of course, the EU members, so the states that are part of the network. Then we have observer countries. So next to European Union countries, we also have Bosnia and Herzegovina, Canada, United Kingdom, Norway, Switzerland, and the US. Then we have 2 EU agencies that are also observers, Eurojust and Europol, and also International Criminal Court holds an observer position, basically Office of the Prosecutor. And then we also have, and this is a really, I think, interesting aspect, is the associates, where we have UN entities. So, for example, within the UN, we have IIIM, so Syria Mechanism, UNITAD, that are both part of the network. Then EASO, so another EU agency on asylum issues, Interpol, International Committee for the Red Cross, and 6 NGOs that are permanently invited to the network meetings as well. So Trial, Amnesty International, FIDH, Coalition for the ICC Redress, and Human Rights Watch. And this was, in a way, kind of going from how the network was set up and how the meeting started, that the NGOs played an essential role in supporting the network in the early days, but also to bring certain expertise. And of course, that developed in a, I would say, very positive cooperative relationship between NGOs and national authorities. But I think whenever you look into the position of being a national prosecutor, you always need to cooperate with external partners. Either that's within the own national jurisdiction, so within other units like immigration or intelligence and so on, or of course cross-border with other countries or with UN mechanisms and NGOs as well. So our focus mandate is, of course, on the crime of genocide, crimes against humanity, and war crimes, which we often refer to as core international crimes, but also torture and forced disappearances. But what we should always keep in mind is that these crimes do not occur in isolation. They are connected with other crime areas as well. So especially, and that's a difference, or I would say also maybe a bit more a privilege of national jurisdiction, that they have the whole penal code in front of them on which they can base investigations. And we have this connectivity with terrorism, illegal migrant smuggling, various forms of trafficking, natural resources, and so on. And of course, some other forms of serious organized crime. We always have, I usually say that the core international crimes are usually the peak of an iceberg, which are the most obvious in many conflicts. But there's the whole underlying structure of facilitating these crimes to occur. The link between the EU and these crimes, of course, that it can happen on the territory of EU member states. In particular, here we still have investigations from in Poland and Baltic states from the Soviet era, but it can also be a very recent, basically, occurrences. There was a recent case in the Netherlands where basically aiding and abetting of war crimes occurred on the territory of the Netherlands with the so-called media mujahideen. So basically a female who was based in the Netherlands for all the time was promoting the material, the videos where there were civilians executed and so on. And the prosecutors put 2 charges against her. One was basically membership in a terrorist organization and propaganda. And the other one was aiding and abetting war crime of inhumane treatment of dead persons. And the nexus was then with an armed conflict in Syria. It can happen, of course, that the link is established by our own nationals because they commit these crimes or can be victims of these crimes, and can happen, of course, in third countries. And then basically the third country nationals enter the EU as refugees, as asylum seekers, but also can be as visitors. In a way, this is when you have conflicts around the world, people tend to flee, which is natural. It's also if you have, you know, a fight in a pub, and then people will try to disperse. But in that way, then basically everyone takes different routes. But you have flows, streams of refugees, and what's important is always to keep in mind, and the experiences show that when you have these streams, in these streams you can have, of course, victims, witnesses, but there can be also perpetrators. That's what we discussed a bit yesterday, I think. There is, of course, obligation to prosecute, but depends on a set of law. States are permitted and in some instances obliged to investigate and prosecute these crimes, irrespective where they have been committed. So that's the idea of the universal jurisdiction. But currently we have only a few countries where you still have very open universal jurisdiction. Majority of EU states require the nexus element, so the presence of a perpetrator on their territory, and that is what actually triggers then the jurisdiction. Also, of course, as we know, these crimes are not statute barred. There's an interesting example of that also coming from the Netherlands. They 2 years ago convicted a perpetrator for crimes that have occurred in Ethiopia in 76. And basically the case, so the perpetrator came in Netherlands in the 90s, acquired the Dutch citizenship, and then later on they identified him as one of the leaders of military in Ethiopia, being responsible for execution of civilians. So in 2018, he was sentenced to life. And if you think that that's like 40 years ago, when the crimes occurred, I always say like justice is slow, but eventually will come. Huh? And another interesting aspect is the possibility to retroactive apply criminal law. So these crimes, and that also comes from the European Convention on Human Rights, Article 7, paragraph 2 is the exception, the only exception on non-applicable, basically possibility allowing retroactive application. There was some interesting case law as well in Estonia, in Latvia, in relation to the crimes that occurred in the 50s, but then they only introduced these crimes in 90s and they prosecuted. And then the court basically decided, European Court of Human Rights, based on Nuremberg, decided that, of course, there can be retroactive application because these crimes are part of international law. So even if they're not part of your national law, they're part of international law. I think we can basically skip that one. Now, what's interesting also within the EU, but often even outside the EU, whenever you want to prosecute, to do these cases on national level, which are those preconditions? What do you need to be able to conduct these cases on national level? And I think here, the most important is, of course, political support. Without that, it's absolutely impossible. And that's what we've seen in all the also European countries when they were setting up specialized units and then basically gaining cases. What was the most important is that there was a decision on a political level, we will do these investigations and cases. Then second, of course, is to have legislation in place. It's fundamental as well. We still have in the EU only a few countries that have not implemented their own statute in full, and hopefully that will happen in the future. Then the resources. So it's not enough that you put a political context and that you have legislation in place, but you also need to have investigators, prosecutors who actually have the knowledge, who have the motivation, who these tasks, basically this investigation prosecution as their daily task. So not something next to 20 other cases, but something where they need to have their eyes and ears open and be able to do that. And what we always, what we see also within the Genocide Network is if you have specialization in place, so dedicated units, dedicated teams, then you will also have successful cases because you retain knowledge, you retain experiences, you basically train your staff how to deal with traumatized witnesses, how to deal with victims of rape and so on. And that stays within the unit and something that can actually then be passed to other colleagues, and you do that structurally successfully. So why is the specialization important? Because also these crimes are a bit different than other crimes on national level. We often look at, of course, ICC or ICTY in the old days, but there you had only these crimes that were the focus of those organizations. On national level, prosecutors are trained to do cases from robbery, rape, murder, and only basically somewhere at the end, it's like core international crimes, but this is not something that would daily apply. So it's a bit, bit of a novelty or a bit of a big issue how to deal with these cases. But of course, these cases are complex because it's the scale, the nature of crimes. If we look at Syria, it's not one street or one town or one house that's a crime scene. It's a whole country that's a crime scene. You don't have one or two perpetrators or victims. You have millions, or at least 10,000, 100,000. And basically also when you conduct these investigations, you're entering into environment of an ongoing conflict or kind of a post-conflict environment. There are always the logistical challenges, especially if you want to travel to these countries. And there are always cultural and other characteristics, differences that you need to take into account. So next to factual, we have legal complexity. So you need to understand the contextual elements. Do I want to prosecute for war crimes, or do I want to prosecute for crimes against humanity? What is the chapeau? What do I need to prove before I actually go to the essence of the crime? Again, of course, it's the effective implementation, dispersed sources of law and immunity. And these are also issues that do present challenges for national prosecutors as well. And then, of course, the third part is cooperation. So you don't have, on national level, you don't have one-stop shop. It's not that in comparison with other crime areas, even if it's complex drug trafficking and so on, your police has monopoly over gathering of evidence. In core international crimes, your national law enforcement is just one of actors collecting information. There are NGOs, there are UN bodies, and all the other actors, even like foreign military, that can do that. So you always need to basically know who you can contact, what can, for example, IIIM bring you, what can UNITAD bring you, who to contact, what can certain NGOs bring you, and so on. So what it means to have specialization kind of in practice is, of course, dedicated units. That's what we have in several countries like Netherlands, France, Germany, Belgium, Sweden, where you have within the law enforcement and within the prosecution, basically dedicated units only focusing on this set of law. Or you can have teams. So within broader units, you train a couple of individuals who can do these cases as well. Training, of course, it's essential. Then multidisciplinary approach, as mentioned earlier, so that you always look at these cases, not in isolation, but basically even from money laundering perspective, terrorism, and so on. And of course, there's always this aspect to retain that knowledge and basically, both best practices, but also lessons learned that you can share with others. What kind of support the network does? So network is a flexible structure. So there is a secretariat where basically we have 3 staff, including myself, but it's the structure, it's the practitioner who support each other, both in kind of operational support, that they assist each other in cases, in expertise. Also, if you have a successful case in one country on a specific theme, it's very likely that that case or that similar team might be successful in another country as well. That's also part of sharing best practice and knowledge. Contacts as well. You saw basically earlier the chart with the membership. So network has basically contacts with all those players. The outreach, we also try to explain. I often get requests from media, either on background information, because of course media is important to explain to general public why these cases need to be investigated and prosecuted on a national level, why you need to put resources in investigating crime that occurred 5,000 kilometers away and not in a local burglary. That's important to explain to public. And what we also do is capacity building and trainings. Some successes of national authorities. We often think of, and also during the discussion, usually whenever we talk about international criminal justice, we always analyze judgments from the ICC or ICTY or what does the judges mean in that particular decision and so on. But we often neglect actually what's done on national level. And we've seen in the past year huge development on national level. And I would just mention kind of a few of the successes in relation to Syria. So we had complete vacuum of international responsibility for the crimes committed in Syria. But the national authorities in the EU were actually pushing this topic further, and we had, or we're having judgments, so final cases, while there's still basically an ongoing conflict. Also, what was interesting in relation to Syria, since there were so many different actors, basically belligerents fighting each other, what we also seen, if we look into the judgments, is that the actual national authorities really took an objective approach. So we have cases against the Free Syrian Army, we have cases against the Islamic State, we have cases against the regime as well. Another success is that actually in this vacuum of international accountability, we had a few countries who actually put resources together, set up a joint investigation team, and acted together to investigate and prosecute regime crimes. As a result of that, we had several arrest warrants back in 2018 against high-level Syrian officers. And we have also recently a confirmation of an indictment of a legal person for complicity in crimes against humanity. So I think that's also what we should take into account as a sort of a development and success. In relation to Islamic State cases, I think a great success is that we see more and more, and that's what Prosecutor Richer was explaining yesterday, this prosecution, cumulative prosecution for both terrorism charges and war crimes, crimes against humanity or genocide. It's something that's also a very important development from, let's say, past years when there was only focus on ISIS as a terrorist organization, and these substantial crimes that they have committed in the territory of Syria and Iraq was basically left aside. And in a way, as we look into successes, I think we should also mention the whole Rwanda, which is for something that goes way back. There have been many national prosecutions in Europe of Rwandan genocidaires. And this is that idea to close the impunity gap. So if they could be transferred, extradited back to Rwanda, that's one way. I said it's always important to have it, to have these trials in the territory where the crimes occurred. The other thing is, of course, if that's not possible, to actually prosecute them in other countries. Just some sort of trends or developments. These are some themes on which we work. So cumulative prosecution, I think I don't need to go more in detail for that. But they're quite fascinating cases, again, mentioned yesterday by Prosecutor Richer in Germany and other countries. So against spouses to be prosecuted for slavery or for enlisting a child soldier, even genocide, but also prosecuting FTFs as well for many of these cases, outrage upon personal dignity because of posing next to decapitated bodies and so on. Another interesting theme is use of open source information. And this is something that's actually very interesting, how it developed basically from 2015-16, both at ICC level with Al-Verfali indictment using the basically Facebook and YouTube videos. And at the same time on national level, we had successful conviction based on information from Facebook, YouTube, and so on, kind of reinforcing each other both on as a jurisprudence on international level and on national level, and then having quotes on each other. Battlefield information, that's again something focusing on predominantly against Islamic State. Basically how you use the information that was acquired during the actual kind of war operations. Sanction embargo violation, that's another interesting aspect that we're looking at as kind of initial step into investigation or as a safety net, because many of these regimes are under embargo, like Syria, Libya, and so on. And then it's interesting to see whether we can kind of extend the idea of fighting impunity also to these violations. And chemical weapons in particular, of course, in relation to Syria, another important aspect. And then situation, yeah, you know where we are with that. Unfortunately, we have more and more conflicts in the proximity of the EU, which requires more and more action and activity from national authorities to be able to investigate and prosecute that. I think I'll finish with this and of course, make myself available for any questions and discussion as well. Thank you.